We can begin, I think. There is no introduction by our dean because they apologize. He's today in Madrid for a meeting, a bureaucratic universitarian meeting, these absurd things in which we spend a lot of time. Then we can begin without any formality. And simply, I wish to thank all of you, especially all of the speakers, for your acceptation to be in Girona these 2 days. Pasa, Pera, pots posar aquí? Gracias. And the organization is more or less like that. We can have maximum 45 minutes for each presentation. Maybe it is possible also, it's up to you to use only 30 minutes, for example, and in order to have more time for the debate, and then a minimum of 45 minutes for the debate of each presentation. In order to organize the debates, we have provided 2 levels of debate. In the first moment, the debate is concentrated between the speakers, okay, and at the second moment, we open the debate to the public. Now, the first conference is by Larry Laudan, that is a researcher in the Philosophical Institute of the Universitat Autónoma Nacional de México, la UNAM, and is now also a visiting researcher in our group here in Girona for 2 months. I am very, very happy for the two things. And the presentation of Larry was the elementary epistemic arithmetic of the law 2, the inadequate resources of moral theory for dealing with the criminal law. It's your time.
Thank you, Jordi. Is the microphone working? You can hear me in the back. Good. I want to begin by proposing a collective vote of thanks from the participants to Jordi and the other organizers of this promising event. It is as rare as it is important for epistemologists and evidence scholars to get together under the same roof and to argue about legal epistemology. For my part, I'm delighted to be here participating in this discussion. My brief from the organizers, in particular from Jordi, was to address myself specifically to questions about the standard of proof. While I'll be doing some of that in my remarks today, that will not be their principal focus. This is because over the last half dozen years or so, I've written a prodigious amount about the criminal standard of proof. Many of you have either heard or read my views on this question to the point that you probably are as tired of them as I am. So I'm not going to bore you by rehearsing arguments that you're already familiar with. Instead, I want to address the question whether moral philosophy possesses, as many applied ethicists insist it does, the conceptual resources to explain patterns of proof and patterns of punishment in the law. I'm not going to read the paper. I'm going to give you a very brief summary in order to maximize scope for discussion. If you haven't read the paper, I hope the summary will bring you in touch with the central theses that I'm propounding. If you have read the paper, I'm sure there will be a huge sigh of relief that you won't have to listen to it again. You may well wonder what, if anything, there is in common between legal proof, which will be one of my foci, and a theory of punishment. I'll try to persuade you that they have a great deal in common, not the least of which is that both require a metric for assessing the magnitude of different harms. It's commonly claimed that the philosophical foundations of the criminal law are to be found in moral theory, specifically deontological theories of the Kantian or neo-Kantian sort. I believe that claim to be greatly exaggerated, since there are core features of the criminal law that are almost certainly not derivable from deontology. This problem arises because the criminal law vitally needs to know how to measure harm, while standard deontological theories provide no metric for doing so. To put it simply, the innumeracy of the deontologists consists in the fact that the only quantitative relations between harms that they recognize are three. X is more harmful than Y, X is less harmful than Y, or X is equally harmful to Y. If that's the only quantification that your conceptual universe admits of, if you're unable to say how much more or how much less harmful X is than Y, then you're at a decided disadvantage in talking about crime, in talking about trials, and in talking about punishment, since, I will argue, they require a much more nuanced vocabulary than less and more offer us. Specifically, I consider in the paper 4 sorts of cases where the limited quantifiability available to a deontic theory of harms leaves us, or at least me, gasping. The 4 examples are these. The first has to do with the standard of proof. Okay, everybody agrees that a standard of proof, particularly in the criminal law, but in the civil law as well, is absolutely fundamental. Without a clearly defined standard of proof, there's no assurance that justice is being done at all. The question is, how does one set the degree of confidence of any given standard of proof? And in the criminal law, of course, the question is, what accommodation does one make for the widespread conviction that false convictions are worse than false acquittals? How should that impact on the determination of the demandingness of the standard of proof? Okay? Typically, the literature is full of folks, deontologists and non-deontologists, all of whom share the conviction that false convictions are worse than false acquittals. And that does entail something, very little, but something about the character of the standard of proof, namely that it needs to be at least as demanding as the preponderance of evidence. Okay? Unfortunately, however, if all you can say, and this, I will argue, is all that deontologists can say, is that false convictions are worse, and from the point of view of moral harm, than false acquittals are, then of course you have this huge expanse of possible degrees of confidence ranging from 51% to 99.9%, within which the standard of proof has to be fixed on deontological grounds, but where there's no particular argument for fixing it at one point rather than another. The way we fix the point, right, is by having a fairly rich appreciation of how much more harmful is a false conviction than a false acquittal. And absent information about that, then the familiar refrain that, of course, the standard of proof in a criminal trial needs to be as near to certainty as we can get it, is wholly unmotivated unless one can establish, as deontologists generally don't, that the degree of harm done by a false conviction is literally orders of magnitude worse than the degree of harm done by a false acquittal. You might say, well, look, you can't derive from standard deontological theories measures of degree of harm of this kind, but deontologists have another resource, another recourse to fall back on, namely invoking intuitions. And on the question of the standard of proof and the relative harm done by false convictions and false acquittals, there is a very long tradition of intuitions. Maimonides thought that false convictions were 1,000 times worse than a false acquittal. Blackstone famously thought that they were 10 times worse. Benjamin Franklin thought they were 100 times worse. Voltaire thought they were twice as bad. Okay? What you have here in this range of estimates, and one could quote a much larger range, but we don't have time, is a difference by a factor of 500 in the estimate of what are the respective harms done by these two kinds of error. So you can pick and choose, as it were, whatever one you want. If you're like Voltaire, thinking that a false acquittal, a false conviction is twice as bad as a false acquittal, then the appropriate standard of proof that should govern criminal trials is roughly confidence of 65%. On the other hand, if with Maimonides you're persuaded that a false conviction is 1,000 times worse than a false acquittal, you want a standard of proof that's at least 99.9%, since those are the things that follow out from the application of a plausible formula about how to generate standards of proof from the characterization of the difference in degree of harm done by these two sorts of error. But the fundamental problem here, of course, is twofold. One, there's no motivation for any of these particular ratios or versions of the Blackstone ratio. What are Maimonides' arguments for 1,000 to 1? What are Voltaire's arguments for 2 to 1? In both cases, they're simply barely asserted, baldly asserted, as intuitively obvious. So, A, there's an enormous divergence among deontological thinkers as to what the gap is, how much more harmful one error is than another. And two, there's no decision mechanism for resolving this conflict of intuitions if you limit yourself to questions of defining harms in terms of rights violated. That's the first point I make in the paper. A related point, one that for me is just as important as the standard of proof argument, but one that I think is not much discussed in the literature at all, has to do with all the other decision rules that guide legal deliberation. Okay? Judges in trials, whether Anglo-Saxon trials or Roman Germanic law trials, all right, are constantly called on to make a huge and enormous number of decisions. Does the court have jurisdiction in this case? Should this piece of evidence be admitted? Should this piece of expert testimony be acceptable? All right? Is a motion from the defense for dropping prosecution accepted or rejected? The list goes on and on and on of decision points in a trial where one hopes that just decisions get made. But for the decisions to be just, there has to be a rationale for the decision rule or the standard that applies in all of those cases. I don't mean to suggest there's one standard that applies in all those cases. In each of those cases, often there are different standards that apply, but in each of those cases, there has to be a rationale for setting the standard at this level rather than at that level. Okay? I believe that in order to justify any of those decision-making standards, okay, we need some sense of the difference in magnitude of the kinds of errors that might ensue from the decision being made. Okay? Once again, since deontological theories don't provide machinery for telling how much worse or better a particular outcome is than another, all right, they seem to me to be mute with respect to the whole panoply of questions about the decision rules appropriate for the multiple decisions that judges have to make. The third part of the paper deals with the question of sentences and punishment. We all know that deontologists regard punishment as, to some extent, their subject. They have written an enormous amount over a long period of time about punishment. When is it justified? Who's entitled to do it? What should be its character? Okay? But what's interesting, if you look at most of the deontological literature, is that you never, although you hear constantly, the legal system has an obligation to deliver just deserts to those people who are convicted of crimes. Okay? That the punishment should indeed fit the crime. That's something close to the notion of just deserts. But of course, and here's the anomaly, you look practically in vain in the literature of deontological thinkers to find any specification at any time with respect to any crime of what the just deserts for that crime would be. Instead, what you tend to get is a rank ordering. We're told, for instance, quite appropriately, that murder is worse than rape, that rape is worse than burglary, that burglary is worse than fraud, etc. The deontologist typically works on the assumption that what he can do is to construct a rank order of the harm done by various crimes, or as Hart called it in his famous book on punishment, the wickedness involved, okay? And Hart believed that you can't talk about degrees of wickedness specifically. You can't say how much more wicked one act, bad act is than another. But what you can do, according to Hart, is to say with some confidence, this act was more wicked than that act, but we don't know quite how much more. The trouble is, at least so I argue in the paper, is that if we're constructing what are called ordinal rank orderings of crimes with respect to their harmfulness or their wickedness or whatever you want to call it, and all we're doing is constructing ordinal rank orderings, then that entails nothing. I repeat, it entails nothing whatever about what the appropriate sentence for any given crime should be. What it does entail is that this, for instance, the sentence for rape should probably be less than the sentence for murder, okay? But if you don't have machinery for fixing either one of those sentences, you open yourself up to a situation in which there are indefinitely many, indeed provably infinitely many, different sentencing regimes, all of which are compatible with and capture the insights incorporated in the rank ordering of the harmfulness of crimes, okay? If you want to see an example of that, just have a quick look at page 11, where I give an incredibly tiny subset of the possible sentencing schedules that would be compatible with most deontological rank orderings of crimes. In short, although there's high confidence among moral philosophers that people should get what they deserve, and that's probably a view that almost all of us can accede to, the machinery for figuring out what it is that someone who commits a given crime deserves is not there, and can't be there until and unless there's some metric for talking about the degree of harmfulness of activity. Talking much more specifically than the lingo of, well, this is more harmful than that, or this is less harmful than that. I also say something in passing about the question of trade-offs between crime prevention and crime prosecution. We all know about the famous trolley puzzle, okay, where a choice has to be made between, on the one hand, permitting a certain harm to be done that may involve the loss of life of several people, or on the other hand, causing the loss of life by throwing a switch of someone. Deontologists are of one mind in believing that causing harm is significantly worse than permitting harm to be done, okay? Again, that doesn't seem a crazy point of view from my perspective. But of course, if you can't say, and they don't, how much worse it is to do a harm than to enable or permit a harm, then you can't begin to think your way through the trolley problem because, okay, there are 5 people on the one line of the track and there's one person on one line of the track. The train is going to kill the 5 if you don't do something to intervene. But if you intervene, that means that you're not merely permitting a harm to be done, you're throwing the switch and causing the death of the one poor sucker on the side track, okay? When and under what circumstances are we justified in doing that? There's not an answer to that question if we don't know the relative magnitude of the harm on the one side of causing harm and the harm on the other side of permitting it to take place. This, it seems to me, is absolutely crucial, this distinction, because there's an ongoing debate in the criminal law, as all of you know, about the extent to which the focus of the judicial system should be on crime prevention and the extent to which it should be on criminal prosecution. Okay? The decision about the allocation of resources as between these two ends, it seems to me, has to hinge on some determination of the respective harms associated with harm doing and harm permitting. In all these cases, my critique of the deontologist involves an assertion about the inability of their project to provide conceptual foundations for the criminal law. In each of these cases, the deontologists come up short-handed because they lack any plausible way of scaling the relevant harms. In the case of the standard of proof, they have nothing but the crudest of intuitions to tell them how much more serious a false conviction is than a false acquittal. Without some more specific and less arbitrary measure of that difference, they can neither derive a standard of proof nor any other decision rule for the numerous decisions that judges are routinely called on to make. And in precisely the same way, so I claim, their inability to measure the differences between the harms involved in different crimes makes it impossible for them to identify the just deserts that, in their view, should be associated with each and every crime. Absent knowing what the just deserts are for any crime, their core retributivist thesis that just deserts should be the engine driving the setting of punishments becomes nothing more than sloganeering. The bottom line, in my judgment, is simply this: until and unless the deontologists can spell out a metric for evaluating the magnitudes of moral harms, they will be unable to say anything very informative about the standard of proof, about the decision rules driving criminal trials, and about the punishments that should be meted out for crimes of differing degrees of harmfulness. Almost a century ago, the American ethicist A.C. Ewing, acknowledging that retributivism faces serious conceptual problems, insisted that we should not be quick to dismiss it out of hand. That might have been sound advice in 1929, when retributivism was emerging from a century of relative neglect. But it doesn't cut the ice any longer, since contemporary retributivists, despite the impressive growth of their numbers, seem no closer to resolving these issues than Ewing was. Until and unless they do, it seems to me appropriate to consider a moratorium on the phrase just deserts, since nobody knows how to identify what they are. One could go on in this vein for hours, but mercifully I won't. Instead, I'll close by quoting a brief observation that Dworkin made in his classic Taking Rights Seriously. Lawyers, he commented, dread contamination with moral philosophy. What he didn't add was, and in many cases, so they should. Thank you.
And the debate is open for the first step with the speakers. Michele Taru.
But just two remarks about what Darius said. My premise is that I share, in general terms, his opinion. So my remarks are not a critique. In a way, one of my remarks is a way of going forward.
Splendid.
And this is because my opinion is that the moralists, so to say, the deontologists, have no exact conceptual criteria even to establish what is a crime and what is not a crime. So I'm not speaking of scales, but just which behavior has to be considered as a crime and which behavior not. And of course, here there is no logic at work, no basic philosophy at work. The explanation of such choices may be found in another dimension of social life, I mean, in religion, in politics. Because, for instance, according to the Catholic Church, divorce is, if not a crime, at least something that is not acknowledged, is sanctioned from the point of view of canon law. There were, or there are, political systems in which behaviors that in democratic system are considered as perfectly normal are sanctioned as crimes. Therefore, to understand why a behavior is punished by the penal code and why a behavior is considered as perfectly legal, well, in my opinion, there are no conceptual or logical justification. The level of these choices is the social and political level. Then we are left with the problem of how and why it has to be the lawgiver, I mean the political power of the moment, to make such choices. They may correspond or not to the social ethics of the moment or to a religious faith or another religious faith. But this relativity, so to say, of such choices derives from the fact that they are made at the political level, not from the point of view of morals or sometimes they are made on a religious basis. So, in my opinion, Larry's argument goes further. I mean, not only the scale of punishment, but also whether or not to sanction this behavior and not to sanction that behavior. On the other hand, if one looks at the criminal codes, for instance, in Europe, from a historical point of view, one may find everything. One of the problems in Italy is that we still have the criminal code of 1930. And it was inspired by the fascist ideology. So you find in the criminal code crimes that shouldn't be punished from a different political and historical point of view. Therefore, not only, I repeat, the scale of punishments lacks any conceptual justification, but even the choice of what is a crime and what is not considered as a crime. Well, as to the scale of punishments, the argument, in my opinion, is the same. Larry is right, in my opinion, to say there is no moral conceptual foundation for that. There are no established criteria. But once again, how to explain the fact that adultery is punished in a way in Muslim countries and is not punished or is punished much less in non-Islamic countries? Well, it is the religion that explains yes or no about this. The social ethics, so to say, the customs, the history of the civilization of a country or of a people. So what can't be explained in terms of conceptual consistency may be explained in terms of historical and social analysis. Of course, how can we establish whether or not a choice is well grounded from this point of view? Well, sociology, history of ideas, maybe that there are ethics, plural, within this complex set of factors. Social ethics, religious ethics, and so on. But the problem of understanding why there is a rule punishing this behavior as a crime and punishing it more or less in comparison with another crime, in my opinion, the explanation, if it exists, has to be found elsewhere. With the problem of whether or not and when is the lawgiver a good interpreter of the social level of conscience about all this. Many times the lawgiver is a bad interpreter of that. The case I quoted of having in 2011 a criminal code enacted in 1930 is a clear case of a huge gap between what one finds in the criminal code and what one finds in the Italian average conscience of this time.
Thank you very much for the observation. That's helpful. I fully concur with the idea that the decision about which acts to criminalize and which acts not to criminalize appear to defy not only deontological theories, but in many cases standard utilitarian moral theories about what acts should be criminalized and what acts should not. 2 or 3 months ago, Ron Allen and I did a paper in which we examined a set of cases in American law in which acts were criminalized that involved no harm doing as such. The rationale for the criminalization of the acts was that the acts in question characteristically represented dangers to the larger society. For instance, in the US, there's a very powerful law to the effect that a previously convicted felon found in possession of a weapon, right, even if it's just in his drawer in his bedroom and he's never been known to use it for anything, goes to prison automatically for a minimum of 5 years, provided it can be proven that a gun was in his possession. That law applies even in jurisdictions, even in states, where for everyone except felons, right, the possession of an arm is a perfectly legal thing. The only conceivable rationale for the criminalization of the possession of a weapon in one's own house in a jurisdiction in which such possession is ordinarily regarded as not only legal but quite common, right, is not an argument grounded in harm doing retrospectively, but rather a hunch prospectively about harm doing. And there are very few moral theories, whether deontological or not, that are prepared to acknowledge the legitimacy of criminalizing acts when those acts have not either actually led to a harm or are literally on the point of producing harm. And we spent quite a lot of time trying to tease this out. What we did not try to do, Ron and I, was to provide any moral grounding for this. And I'll leave it at that.
Paul Roberts.
Thank you.
It's better if you use the microphone in order to make possible the registration.
I normally don't need it, but if you say so. Larry, you know I'm a great fan of your work, but there's more preamble before we get to the book, okay? There will be a book. One of the many things I admire is your willingness to engage with interdisciplinary questions, and allied to that, your willingness to stick your head over the parapet and put a thesis out. And I know you put that out for discussion. So on that basis,
Please.
all this kind of interdisciplinary work poses really serious methodological challenges about basic concepts that we're using to discuss the problems, the basic categories and taxonomies that we're using. For example, if you define retributivism as a theory of punishment, then by definition it will not answer the criminalisation questions that Michaela has just raised.
Right.
Because criminalisation is one question and the theory of punishment
Absolutely.
is another. Now, there might be a deeper basis on which these two types of questions can be brought into a coherent, broader scheme, which may be some version of Kantianism or liberal human rights theory or utilitarianism, if you must, but it will be some other theory. So there's a problem of levels here already emerging in the discussion. But even more fundamental, well, for these purposes, even more fundamentally than that, we need to think about the way that these taxonomies map onto disciplinary categories as well. At least twice in your presentation today and in the paper as well, you refer to the literature. Now, I'm not sure what literature you're referring to here. I think I know, but I'm not sure. When you talk about moral theory, I think you mean that quite precisely. But that, off the bat, strikes me as deeply problematic, because I would have thought these questions are questions of political morality, not just of moral theory in a more technical sense. So, as far as I'm concerned, the obvious approach to these questions, which clearly concern not only the morality of just desserts, but also relationships about state authority and the individual and questions of harm, prevention, all of these questions. It's obvious to me, obvious off the bat, that these cannot be resolved purely by moral theory in the technical sense that philosophers use it. It would have to be also concerned with all the issues, and we can use lots of different language here. There are translation and language issues here, but you talked about politics, you talked about ethics, you talked about social theory, religion, all of these different things. I would bring, for me, the relevant criteria, relevant normative criteria, all come within a capacious concept of political morality. I'm telling you about that as where I stand on this, so you'll understand what I mean when I speak, but I think this is a problem here. So let me just crystallise this into a very, very sort of pointed question now. You quote Andrew von Hirsch in an old paper saying, isn't it strange that no one's trying to work out this stuff in much more detail? It's your challenge in your paper. But you don't mention the fact that for the last 30 years, Andrew von Hirsch has written 3 books doing precisely that, arguing in detail how these problems are to be overcome. Right? Now, part of the reason for this, I think, and I agree with you here, part of the reason for this is because the subject known as penal theory has become strangely detached from general moral and political theory. And I suspect, and you correct me if I'm wrong, but I suspect you read the philosophy journals. You don't read the specialist literature on penal theory, where these questions have been hashed out in very, very considerable detail. And these are not just theoretical challenges. Over the last 25 to 30 years, the theory of just desserts has swept many Western European theory of sentencing and sentencing practice, and the laws of sentencing in Sweden and in England and Wales and elsewhere have been reformed in accordance with these theories. They've been put into practice. Now, to hear your paper, you would think that this stuff was lacked such basic criteria of applicability that it couldn't possibly be implemented. And yet, for the last 30 years, we've been implementing it and refining it and using it. It's just bizarre. It's a little bit like someone saying to somebody who's working on theoretical physics or something, oh, no one's yet found the grand unified theory of Newtonian physics and quantum mechanics. Ergo, we can't move forward until someone does that. But the answer to that is, but planes fly, and they fly not just on the basis of what you call untutored intuitions or mere intuitions or something like that, but on the basis of an account that can be given of better or worse versions of whether jet engines work or not. I think there's a direct parallel to penal theory and penal practice. Not only can you do all the things that you mentioned in the paper, but we are doing them day in, day out, all the time. The planes fly. What we can't do, and I will shut up in a minute, what we can't do is answer the very precise, probabilistic challenges that you set. Because it's not a probabilistic problem in that sense. It's to do with, yes, deontological moral theory. It's also to do with an account of political morality. It's also to do with cultural variation and procedural traditions, and a whole load of other stuff that fits more within sociology or cultural studies than in philosophy. My conclusion about all that is not that there's a problem with the practice, it's that there's a problem with your questions. Questions that have been posed from, as it were, a mathematical or probabilistic perspective. Sure, you've raised questions that we can't answer, and I'll hold my hand up now. I am a liberal deontologist. You've posed questions that we can't answer. But that's because I think they're bad questions, that we don't need to answer them. And finally, one last point. In terms of criminal procedure, Robertson Zuckerman is 400,000 words worth of trying to elucidate the meaning of those kind of neo-Kantian precepts about human dignity and apply them to the detail of English criminal procedure in working out in terms of criminal procedure, including burden standard of proof and presumption of innocence, exactly those kinds of questions that you posed at the beginning. So I think this is being done, but not to meet the criteria that you've set.
Thank you for an incredibly detailed agenda of points to respond to. Across the Western world in the last 30 years, as you know as well as I, there has been a series of fairly fundamental reforms of sentencing policies in one country after another. And sometimes these initiate through a straight process of political morality with a Congress or a parliament decreeing, you know, here are the sentencing guidelines. In other cases, they emerge from the activities of various experts, sometimes judges, and so forth and so on. There's no doubt, but, and the last thing I meant to suggest was that most societies don't have a system, a schedule of punishments for crimes. They do. And they are constantly reforming them. The issue that I tried to address from the beginning of the written paper, and I think it certainly, I hope, was fairly prominent in my oral remarks, was not, can we work out a theory of sentencing? I think not only can we have, okay? The question rather was, to what degree, if any, are existing sentencing policies grounded in or groundable in, all right, traditional Kantian deontological theory, and in particular in the theory of just deserts. Let's focus on that issue for one particular minute. The whole motivation behind the theory of just deserts, okay, is in effect an anti-consequentialist motivation. The idea is that the punishment meted out to somebody who's been convicted of a crime should reflect the harm or the wickedness, in Hart's language, that was involved in the commission of the crime, that it is a purely retrospective judgment about that crime. It must involve, and this is what's at the heart of the just deserts theory, it must not involve prospective questions of deterrence. It must not involve prospective questions of the danger posed by the person who's just been convicted of a crime. And in general, it shouldn't treat, again, Kantian language, it should not treat the convicted defendant as a means rather than as an end. Whereas treating him as a means would mean making his sentence in part reflect judgments about his likely danger to the community. It would involve taking into account not merely the crime for which he's just been convicted, but his prior criminal history. It would mean using the conviction of this person as a deterrence mechanism for discouraging other people from engaging in the acts that he engages in. It is a matter of, as far as I can see, absolutely firm orthodoxy among standard moral theorists of a non-consequentialist sort to insist that sentencing, whatever else it does, must depend on retrospective judgments about the horribleness of the crime and no prospective judgments about the dangers posed by the individual who committed it. Now,
that's the crux. That's the crux right there.
Yeah.
No modern penal theorist that I know believes what you've just said.
No.
Including all the just deserts people.
I'm sorry. Tell me somebody who is a judge. Well, look at what he did. You're quite right that he came out after acknowledging in this J. Phil article from the 1970s that we really did need to make some headway doing this. So what did he do? Did he attempt to derive from a moral perspective a set of sentences that it would be reasonable to impose? No, what he did...
No, that's exactly what he's done.
No, I'm sorry. What he did was to conduct a significant amount of empirical research.
No. Before he did the empirical research, he wrote the book.
Yes?
No, he did the empirical research afterwards, and that was just with criminologists. The theory was already worked out in terms... You see, what modern just desserts theorists believe, they're not Kantian. No one's a Kantian. Kant said the last murder on the island should be punished. It's the same as the Maimonides thing that, you know, if you save one child, you save the world. If you want to do numbers, if you save one child, you save the world, that's pretty comprehensive from a numbers perspective. So let's get away from the numbers. But all modern just desserts theorists believe that proportionality is central. And they believe that proportionality constraints must be satisfied. And if you want to put that in Kantian language in terms of not treating the individual as a means to an end, that's fine. That is rhetoric, really, but it's okay. It's a nice way of putting it. So proportionality sets parameters for modern just desserts theorists. Within that, as long as those parameters are served, other considerations can be brought into account, including future-oriented considerations about prevention, rehabilitation, and so on and so forth. All modern desserts theorists, to my knowledge, believe that. I don't think there are any out-and-out Kantians left.
Philosophy departments are full of them, I'm afraid.
Yeah, well, but this is the point, Larry. The people who are described as penal theorists don't work in philosophy departments, and they don't write in philosophy journals. So it might be that your criticism is not of the substance of the thing. Your criticism, I put it to you, and if this is your criticism, I agree with you. Your criticism is actually of the state nature of the debate in philosophy departments.
I thought that was clear from the beginning.
No, it's not. No, the argument that you put is an attack on the possibility of just desserts theory. You don't say this is an attack against philosophy departments. And what I'm saying to you is you're attacking actually against philosophy departments. And if it's that attack, I like philosophers, mostly. But in this respect, I think there is a problem. I think penal theory has become detached. And by penal theory, I mean proper philosophy of punishment, not some, poor relation. I mean proper philosophy of punishment, the stuff that's done by von Hirsch and Anthony Duff and Doug Cusack, and people who are really good at this, John Gardner, etc. Apart from John, they don't write. They're not in philosophy departments. They don't write philosophy journals. But it's done in penal theory, and lots of these questions have been worked out over the last 25 years.
By transforming just desserts theory beyond traditional recognition.
Well, it depends what you mean by traditional. If by traditional you mean Kantian, then sure, yeah, it's not Kantian. But Kantianism is a slippery slope. Because for a start,
by it, I don't just mean Kant. I mean, look at Hart. Hart says, for instance, that what we've got to do is, if we're doing just desserts theory, we've got to make the crime precisely proportional to the wickedness.
But Hart's a utilitarian, and his thought on penal theory never got beyond about 1968. So if you're describing the debate in 1968, I agree with you. But if we're describing the debate today, that's not the nature of the debate. I'll put it to you.
Among penologists.
Among people who do just desserts theory, including all the people I regard as just desserts theorists. And American law schools are full of them, actually. And some of them are quite good.
Well,
I'll leave you to draw the inference.
Ronald.
Well, I had two comments about Larry's paper, but I think I'll start with the first comment about Paul. I'm inclined to begin by saying, Paul, I'm a great admirer of your work.
I'll take that.
But, I don't mean to be offensive here, but in Spain I can't resist a play on an old thing Samuel Johnson said, like, when I go back to the United States, if I'm asked, do I believe in the Catholic Church, I'll be inclined to say, do I believe in it? I've seen it with my own eyes. Now, to say I've seen the Catholic Church with my own eyes doesn't mean I believe in the principles the Catholic Church stands for. So, Paul, when you say that there are, for 20 or 30 years we've been working out this theory of punishment, and there are better and worse versions of it. The question or the response that Larry should give is by reference to what? Is one version better or worse?
Just desserts theory. It has to be just desserts theory.
By reference to what? Is this a better just desserts theory or a worse one? And the answer to that is going to be, and this is, I think, what's implicit in Larry's perspective, a subjective aligning of harms. But if it's subjective, that I think this is worse than that, then it's not much of a better theory or a worse theory. It's not what we mean by a theory. It's simply a counting, a political counting of individual preferences. If that's what you mean by better or worse, fine, but the point is that's all that there is. There is nothing to judge the better or the worse except some subjective set of references like that, which is what the point of, I thought, Larry, the point of your, in a way, your paper is. That that's all that there is left. It's an edifice built on the quicksand of subjectivity. So I don't know if that's right or if that's wrong, but that's what I was thinking when, that is, I don't know if I'm characterizing your thinking correctly or incorrectly, but that's what how I would have responded, not to accept that there is this work on just desserts theory out there, but to critique that just desserts theory from exactly the perspective that you are critiquing the moral questions in your paper, and I think you'd be right about that. One can say I agree with English sentencing law, and I disagree with Spanish sentencing law, but it's but on the basis of what?
That's not the claim. I mean,
so let me just. So that's point. So point number one. You're just simply missing the point. There's a lot of work. The United States has been one of the leaders in this on supposed retributivism and retributiveness in punishment. But the question is, what is it itself based upon? Is it based on something deeper than simply our subjective beliefs? And if the answer is no, it's a crummy theory. It may not be a crummy political process or a crummy sociological process, but it's a crummy theory from the perspective of what I think, Larry, you mean by a theory. So that would be my defense of this, and I'm curious to hear what you have. Maybe you should comment on that now, because I have two other points that are quite different from this. Do you have anything to say about this?
Well, I'm still sort of in a mild state of shock with respect to the suggestion that just desserts theorists can appropriately include questions about prospective danger, questions about deterrence, questions about incapacitation, etc., etc. Since if that is what penologists are now working with, and I think it is, then there is no sense at all in which they can adopt as a label for describing themselves just desserts theorists. Because if one is assessing in terms of setting a sentence for a convicted person, judgments about how dangerous will he be in the community if we give him less than a 5-year sentence, okay, then you're not asking at all the question of what would be a just desserts punishment for the crime for which he's just been convicted.
Just on that, what if first of all, just desserts is not a point on a scale, but is a rate?
That's fine.
Okay.
Exactly the same same argument applies.
And what if? Okay, good.
Because if the limits of the range are determined in part by assessments of dangerousness, then you're not sending the guy to jail entirely on the strength of how bad his last crime was.
You see, the thought is, you have to think that there are a range of possible punishments with equal penal severity. So that from a just desserts point of view, the punishments are fungible. You see, if you only think in terms of years, this won't work. But if you think in terms of jail sentences or particular programs or custodial, non-custodial sanctions or community sentences or a mixture of the two or particular types of programs, then you can see a range of possible sentences, all of which can be regarded as having equal penal content, equal severity from a just desserts perspective. At that point, the just desserts theories is perfectly entitled to take into account future-oriented considerations, if you like, consequential considerations, in choosing between punishments of equal penal severity.
Quite why it's perfectly entitled to do so is still up in the air. But consider, for instance, the table I give, I think, on page 11, of the sentence ranges for 6, 5 crimes in American law at the moment. Now, sorry, it's page 12, okay? Consider the sentencing ranges. This is in U.S. law the result of very serious penal reform starting in the 1980s and continuing up to the early years of this decade. We find, for instance, the sentencing range for murder is 10 months to life. For aggravated assault, 3 to 8 years. For fraud, probation to 12 years. Now, what we have, in other words, is a system where, with respect to homicide, the range is so large, 10 months to life, okay? The range is so large that the idea that this is capturing the just deserts that might be associated with different forms of homicide strikes me as loony.
That range supports just deserts theory, in my view. Because honestly, it does. Listen for why. In that specific point, there's a major type token problem in your analysis. Just deserts is not about the type of crime. It's not as if there's one punishment that matches all murders. Particularly if your category of murder covers mercy killings at one end, people who desperately want to die, and felony homicides by bank robbers at the other. The idea that those people deserve the same punishment from a just deserts perspective is nonsense. The point about the scales is that they allow the judge to accommodate the sentence in the instant case to the desert of the particular offender, and that's a just deserts argument. So I don't see any of that to just deserts.
Okay, Ron, have two other questions, okay?
That leads to my first. So, Larry, I think the real point that you're making here is that it's all this is subjective much, which is what I think Paul is trying to pretend he's not. Yeah. Unsuccessfully, but no, you pretend like the Catholic Church. You're pretending successfully that it's not much, but it is. And so I wonder if you actually give up too much in your argument by accepting that even ordinal listing can be done. Like you said, you start by saying, well, this is just okay. Murder is worse than rape is worse than burglary is worse than fraud. Now, some of those I may agree with, but I think that's as equal.
Probably all of them.
Well, no, I wouldn't. There are some rapes that I would say, are worse than murder. There are some burglaries that are worse than some rapes. But why is that? The reason is that these are subjective assessments, not objective assessments. There's no objective ordinal ranking. So if you give up that you can do an ordinal ranking of categories of acts, it seems to me it follows pretty easily the mush stuff that Paul was arguing.
Or call it 2.5 millennia of moral theory or moral epistemology.
Whichever you like.
Okay.
Exactly. So it seems to me that you want to think about that proposition because your main point is subjectivity. That what you mean by a theory is something that's an algorithm, something that has a deductive structure to it, and that the subjective components of deciding the amount of punishment is what is offensive to you. But it seems to me that is equally a part of the ordinal rankings of these things. And then my related point, I want to get it in because I might not have an opportunity. But my other point is that I think you're quite different from that. I think another way to understand your argument is there's a knowledge gap. That we don't have the knowledge necessary to generate the sentences to make it look like a theory that's actually functioning as a theory. I think that's true. Obviously, I think that's true, at least if you accept the subjectivity, objectivity point that I make. But it's also true of any other theory of punishment. Now, I don't know which way this cuts, but to, for example, talk about structuring punishment for deterrence reasons, you need to know the relationship between your actions and deterrence. Right? To talk about the incapacitation, you need to know the relationship. So there's knowledge gaps everywhere. And so I don't know whether that matters, whether that supports, undercuts, or whatever, but the same problem from this perspective seems to be true of all criminal punishments.
Shall I comment?
I'm not running the show.
Yeah.
I'm just responding to Paul.
I'll try to be brief. Is subjectivity what's at the core of all this? I don't think I'm prepared to make that charge. And the reason there are several reasons why. Return to the argument I made about the standard of proof and the difficulty that deontologists have with justifying a particular standard of proof. Okay? They begin with a premise that it seems to me is quite clearly sound, namely that a false conviction is indeed worse than a false acquittal. I believe there are essentially analytically true arguments that one can mount to show that, since any false acquittal is, any false conviction automatically entails implicitly a false acquittal. And therefore, it must be the case that a false conviction is a greater harm than a false acquittal is. I don't take that to be a subjective claim. It seems to me people on all sides of the moral spectrum, whether they're crass utilitarians or deep-rooted Kantian deontologists, have a point when they say that false convictions are worse than false acquittals. My charge against them...
So false conviction for stealing €1 is worse than a false acquittal for a serial murder. That's crazy.
That is crazy, but that's not what the thesis implies.
Well, false conviction is worse than conviction is worse than false acquittal. It depends on what it is. If you're talking just about the single event.
That's exactly what we're talking about. And so my claim is that on that front, at least, what's wrong with the deontological analysis is not that they've got the rank ordering wrong. They're right to think that false convictions are indeed worse harms than false acquittals. The problem is that since they don't have any machinery for telling us how much worse a false conviction is than a false acquittal, okay, they can do nothing, so I argue, to specify specifically which bit of this large range between 50% confidence and 99% confidence is the appropriate level for the criminal standard of proof. That for that, what we need and that what they don't provide, and empirical information can provide it, in my view, is information about how much more harmful a false conviction is than a false acquittal. Okay? So I'm not claiming that their initial rank orderings are necessarily subjective. What I'm claiming, in a way, is something more, I think, more fundamental and more profoundly troubling than that. Namely, that even if you grant them that the rank orderings appear to have a significant degree of plausibility about them, what you can't do, short of determination of degrees of harmfulness, is move from those ordinal rank orderings to any claims about what the standard of proof should be, what decision-making standards in a trial should be, what the sentencing schedule in a given community should be, that you need desperately to have measures of degrees of harmfulness if you're going to be able to argue for a just system of trials, of sentencing, of punishments, and of distribution of resources as between crime prevention and crime prosecution.
Okay, someone else? Susan.
Okay, so this is going to sound...
Sorry?
This is going to sound very simple compared with the stuff that's being done.
I'm delighted.
Okay. First of all, the table on page 11 is it's very effective. But I have a suggestion about something that you might add that would make it even more effective.
Please.
This is from something I know about only from newspaper reports. They were in more than one newspaper, and I think are probably reliable. From around 2006, where a very young man in Pakistan, I believe he was 12, was convicted of raping an older woman. And the punishment, the legal punishment for this,
was that she was beat or something?
Was that his sister was raped by the men of the family of the woman whom he had allegedly raped. Now this is fitting the crime in some really very dramatic sense.
And literal.
Damage our goods, we will damage your goods, is essentially the thought behind it, I take it. It has, of course, I take it, very little, if anything, to do with Kant. Okay, that was the first thought. This prompts...
I'm not sure it has very little, if anything, to do with Kant. Kant, in effect, was heavily influenced by the lex talionis tradition.
Okay, so maybe, yes, I was thinking of the other direction.
Yeah.
Yes, okay. This leads me to a sort of string of questions. These are real questions, they're not disguised objections. Okay. It isn't yet clear to me whether you think that it's inherent in deontological theory that it cannot provide the metric that you're asking for, or whether it's just that the people in this area who have so far tried have produced nothing but what Ron would call mush.
Lovingly.
And if that's the case, I'm curious about what the argument is, why in principle they can't do this. And if, again, that's the case, then I'm curious what you think about whether any other kind of theory overcomes this in principle difficulty.
Okay, that's a rich question, rich set of questions. I think that my initial response should be along these lines. The inability of deontological theorists in philosophy departments, Paul, to come up with a schedule of appropriate punishments that are, in fact, plausibly claimed to be just deserts, after now practically a century of the dominance of theories of retributivism, right, is prima facie grounds, given that retributivist theories have been routinely criticized by their critics, most especially by the consequentialists, that they can't say anything of interest about specific penalties for specific crimes. That's prima facie evidence that those theories lack the resources. But it's not a completely compelling argument that they lack the resources. If I were to try to construct an argument along those lines, it would be of the following sort. If you look at the standard ways in which deontologists in philosophy departments grapple with these issues, the idea is that you define the degree, or you qualitatively identify the harmfulness of an act by asking, what rights of the victim did it violate? Okay?
You have these ordered in some way already.
Well, yes. For instance, the right to life is clearly more fundamental than the right to property, because if you don't have the former, you can't possibly enjoy the latter. So you can work out a scheme of interrelationships between rights that, A, does not require you to tell how much difference there is between them, but that does allow you to say this is worse than that, particularly if the this involves the violation of rights that were also involved in the that and something else besides. So there is a theoretical argument to be made that unless there is a way of measuring, of metricizing, okay, the rights that can be put at risk by criminal activity, and no one has made the claim that they know how to do that, right, then it appears that there is a good reason to say that the reasonable expectation is that just deserts theorists are going to continue to satisfy themselves with ordinal rank orderings, because that's what they can get from this catalog of which rights were violated by which criminal acts and which of those rights is more fundamental than another, okay, without requiring them to quantify specifically what the degree of rights invasion was by a particular act. So that would be, as it were, a principled argument, that so long as you're making your assessments of the wickedness, I'll continue to use the Hart's language, the wickedness of an act, if you're continuing to tie that to the rights that were violated, the rights of the victim that were violated by the perpetrator of the act, then it seems to me there's grounds for saying, if that's the philosophical foundation for the theory, then there's no way you're ever going to be able to talk about differing degrees of harmfulness.
Are you assuming that it's impossible in principle to do anything metric about the rights being violated?
Yeah.
Also?
Yeah.
Okay.
I have a question then, and then open the debate to the other people. I think, Larry, that I agree with you in the fundamental point of your paper, but I think I agree in that is not said in the paper, but I think you think. More or less, I think that your position is, or your critique is under-inclusive, okay, in that sense. Actually, in my opinion, the deontological moral theories about criminal law doesn't provide the type of scales and the metric that you are asking for. But why doesn't provide this? In my opinion, because nevertheless the question about how much strong ought to be the standard of proof, or how much strong have to be the penalty for a crime, is absolutely a moral question. A religious, a political, but politics and religion are moral things. This type of moral questions have no objective answers. It is not a problem for deontological moral theories. It's a problem for also consequentialist moral theory. It's a problem for moral theory. There is no objective answer for moral questions. And if these type of questions are moral questions, there aren't objective answers. Then the only answer that we can do to this type of questions is a moral political decision in each state and each moment, and for these questions. And it's not a theory that can provide the answer. It's only a social decision.
Okay. I think I would take exception with the claim that the problem that I've tried to put my finger on with respect to classical Kantian moral theory is necessarily reflected or characteristic of all moral theories by virtue of being moral theories. My own moral preferences are decidedly consequentialist, and whatever its other weaknesses, one of the strengths of consequentialism is its insistence that one must get empirical information about the consequences of actions and decisions before one is in a position to say that the action or the decision was a rationally well-founded one. In the case, for instance, of the standard of proof, suppose we were to take seriously Maimonides' idea, got to be 99.9%, right? An examination of the consequences in terms of political morality of setting up a standard of proof that would mean that virtually every guilty person was acquitted would be unthinkable, unacceptable, and not merely for subjective reasons, because the costs that society would have to bear from the implementation of a standard that was 99.9% confidence would be one of chaos, disorder, high levels of crime, high levels of victimization. So I conjecture we need empirical evidence for that. I think there is some already. And so I'm not willing to concede that any posture or perspective within political morality is intrinsically emotivist, inherently subjectivist, okay? I do believe that deontological theory has that characteristic, but as I think I said in the last sentence of the paper, at least in one version I wrote, I leave wholly open the question whether, with respect to non-deontological theories, there can be said to be a rationale for characterizing how much or how much less, how much more or how much less harmful one act is than another.
Okay, thank you. Let's open the debate. Maribel. Maybe you can use the microphone. Yeah.
I'm not sure the people behind you can hear.
I think that for philosophical reasons, on philosophical basis, I agree with your paper and your presentation.
But
No, I agree. And the but is not the same type of but. But I think that can be applied also, the same reasoning can be applied also to something that I guess you don't apply to. Because you talk about, for example, levels of victimization.
yeah,
Sociological studies and criminological studies that try to measure well-being, victimization, perception of crime. All this way of working is based on a concept that can be classificatory or nominal scale level.
yeah.
They try to produce an order, they do it, and finally they use the ratio system to put a measure. And then you has been talking here, for example, levels of. Levels of means that you can measure that. Can you? Because if you believe, maybe we use that stuff, that we can talk properly about the levels of whatever in society, then it's because we did something similar that you say we cannot do with, how was the word? Victims' rights destroy. Well, no, tell me.
The Innocent Project?
We cannot order the rights, the harm to our rights. So if we can do it for risk, if we can do it for perception, I think we cannot. But if we talk, about victimization levels and perception levels, then maybe a sociologist can say, well, let's say your mother was crying 2 days, you have a son, and then to put the scales and to share, this is a better, highest level than this one. Because I don't believe in that process in social science, I think that you are right. But if you are right, we need to avoid the sociological construction of measurements for social stuff.
I think from my point of view, it will depend on the kind of measure, the kind of metric that's constructed. I'm quite happy to talk about the kinds of measures, for instance, that one associates with the theory of utilities in economics, okay, where what we are dealing with are ratio rank orderings that tell us something about the difference in worth or value or pain or harm between A and B. The trouble with ordinal rank orderings of the kind that traditional deontologists focus on is that they don't tell us anything about the size of the gaps between the items that are in the rank ordering. It's simply 1, 2, 3, 4, 5, 6, right? Whereas in the case of an economist who's using util calculations, okay, his rank ordering is apt to be something like 0.7, 4 next one, 4.9, next one, 11.6, and the distance, as it were, between the utils of the different levels is a reflection of how much worse or how much better one element in the list is than the other. What it seems to me, if we're going to have a reasonable sentencing schedule, we need is to adopt a ratio rank ordering, to put it together, ground it as firmly empirically as we can make it, rather than constructing an ordinal rank ordering, which will never, I believe, put us in a position to derive, to say of any particular punishment, this punishment is what the felon, what the convicted person deserves, and that punishment is not. Similarly for the standard of proof, provided we can tell what is the gap in harm done between a false conviction and a false acquittal, then there is some hope that we might, at least on paper, be able to figure out what should be the demandingness of the standard of proof. But if all we know, if all we can say with confidence is a false conviction is worse than a false acquittal, then we are in effect saying we're in no position whatever to say anything about the standard of proof, except that it better be at least the preponderance of evidence, and it can't be greater than certainty. And that's just not good enough for figuring out what the standard of proof should be. It defines a range that's so vast that it permits too much mischief.
Yes.
Sure.
I didn't talk about economy.
No,
Specifically.
you talked about sociology.
Good to know.
Yeah, yeah.
Because in economy, we can use what is called a unit of measurement,
A
you know,
unit.
and we have the zero absolute, you know.
Exactly.
Then in sociology, we don't have that. We are in the same position that talking about punishment, but we invent easily with a regression line how to make the numbers. And then in that way, we can have the arithmetical properties of our measurements. So my question was, if you, and I agree with you, says we cannot achieve this on that area, moral, philosophy,
right.
politics, talking about punishment, then we would be the type of people that don't like or don't accept or don't think that is grounded the sociology, when in social sciences we use measurements in the same way. You say that is not possible. Not in economy. Economy is where against the use of some sociologists, because they don't have what is called accountable. That is,
right.
numbers that represent, for example, money.
Right.
Or numbers that represent numbers are possible objects of measurement, but numbers that represent feelings are not.
To the extent, in my view, to the extent that sociology produces ordinal rank orderings, then to precisely that extent, it can't address the appropriateness of different kinds of remedies for social problems, because it has no way of balancing the more acute problems and the less acute problems. It has no way of deciding what proportion of resources should be allocated to what kinds of crime, is the problem of crime worse than the problem of the economy? Well, if the only answer is, well, no, the economic problems right now are worse than the problems of crime, that still leaves completely open the question of how society should allocate resources as between solving the economic problems confronting us and tackling the issue of crime. Okay, we need to know something like how much worse is the economic situation than the crime threat, or vice versa. Once we know that, we can make reasonable allocation decisions about our time, our resources, our intellectual energy. But if all we've got is a rank ordering, I'm sorry, it's like a Christmas gift list that you get from your child. You know, these are the following 5 things I want, and the first one costs 10,000 euros, and the second one costs 4 euros, and you know, if you're a reasonable parent, you'll say, I'm going to give you the second and third, not the first.
Giovanni Tuzet.
Coming back to the question that you were discussing before, I didn't understand what your argument is against the idea of sort of division of labor between moral philosophers, lawyers, and other people. I mean, it's reasonable to think that the moral philosopher could give an argument for the idea that murder is worse than fraud, for instance. But after that, maybe it's reasonable to think that how much more the punishment should be. It's not the business of the moral philosopher. It's something that it's reasonable to leave to our political institution or to the lawyers. So I don't understand why you want the political, the moral philosopher to give an answer to that.
Well, to the extent that the moral philosopher claims that the criminal law is his province, and many moral philosophers through the ages have made precisely that claim, okay, that they have a theory of punishment, that they have a theory of the standard of proof. I mean, look, for instance, at the number of prominent moral philosophers in the 20th century who address the question of what should the criminal standard of proof be. Okay, you have Dworkin, you have Hart, you have Ewing, a whole sequence of philosophy department-based philosophers, right, making claims for the capacity of moral theory to shed light on, to clarify issues that have long been sort of puzzles in the criminal law. Okay? The reason why I focused on the two puzzles that I chiefly did in this paper, namely the one being the standard of proof, the other one being the fixing of appropriate or just sentences, is it seems to me that the ambitious claims that have been made by the likes of Dworkin, for instance, about how moral theory and moral theory alone, and not just moral theory, but deontological theory, because Dworkin says the consequentialists can't do this. But we, the moral philosophers of a deontological sort, can uniquely justify a very demanding criminal standard of proof. Okay. He then gives an argument that I rehearse in the paper. It's an unbelievably bad argument. It makes two fundamental mistakes. One, he assumes that that proof beyond a reasonable doubt is the most demanding standard that humankind is capable of conceiving. False, Professor Dworkin. And he makes the claim that the state is under a moral obligation to do everything within its power to prevent the false conviction of innocent defendants. Again, you're wrong, because if the state did everything within its power to prevent false convictions, there would be no convictions of any sort, true or false. And here we have perhaps one of the most prominent philosophers of law of our time kind of stumbling all over himself when he starts trying to talk about what are really epistemological questions having to do with the structure of a trial, and he thinks he can provide a basis for the answers to those questions in moral theory. And I think it's transparently clear he can't, and he doesn't. And I guess I'm wanting to say, just as we epistemologists, I consider myself one, should not overreach ourselves in terms of claiming, for instance, that we can address all kinds of issues of political morality that we have no particular competence at. It seems to me questions of proof, at a minimum, are fundamentally, although they can involve some elements of political morality, they're fundamentally questions about the nature of justified belief, about how one determines whether a particular standard of proof is coherent, acceptable, sufficiently robust, or too weak, etc., etc. Those are fundamentally epistemological questions, not moral ones. And I think it's incumbent on moral philosophers to quit asserting their territoriality with respect to being those who provide the philosophical underpinnings for the law. Because while they do provide some philosophical underpinnings for the law, there are many other areas of the law for which moral theory, be it consequentialist or deontological, provides no underpinnings at all, and that if we're going to talk seriously about what the philosophy of law is, and I take it that that in some ways is the most important conversation in which we're engaging, okay, we've got to see that the philosophy of law includes vastly more than political morality and moral theory and ethics. It's logic, it's the theory of knowledge, it's the theory of justified belief, it's the theory of proof, every bit as much as it's questions of morality.
We have 5 minutes yet. If there is any other question. Michele,
Can I reverse the order
Yeah?
of the discussion? But just to say one thing, which is reasoning as a lawyer, I have to say that there are areas of the law that are lucky, tienen suerte, areas of the law that are not lucky. From this point of view, criminal law is not lucky because of all these quarrels between moral philosophers and so on, Department of Philosophy versus so on and so on. Think of private law. I'm a scholar mainly in civil litigation and not in criminal. As far as I know, nobody raised such sophisticated problems, for instance, trying to find out a moral justification for punitive damages in the United States. Although punitive damages, before the 3 times limit, could cost millions and millions of dollars, punitive. And the justification that the lawyers always gave for this sanction, which is typically a sanction, was deterrence. So no theory of just desert on this on this case, because punitive damages is punitive, is a sanction projected to the future. This is the classical justification. And this is why, for instance, in civil law systems, we don't have punitive damages. So that judgments allowing punitive damages in the United States are not acknowledged in European courts. Nobody tried to find out the moral justification for compensatory damages. One can say, well, Aristotle in his theory of justice thought, but here we are with the legal theories of justice, not with moral justification. That's why I said the scholars in private law are lucky, because as far as I know, they are not required to confront themselves with such sophisticated and difficult problems that probably have no answer. So as a scholar in private civil litigation, I found myself very lucky this morning. Thank you.
Just to respond very briefly, what would you say, Michele, about whether tort law is lucky or unlucky? Because that would appear to be a part of private law in which taking fairly seriously philosophical theories of causation is crucial.
From that point of view, yes, but not from the point of view of moral justification.
No.
Well,
Okay.
there are people that work on that. I mean, whether you really or not is another question. I mean, you might think you're lucky if you just ignore all this stuff and get on with your job. You know, I mean, Jules Coleman, spends most of his time writing just about the moral theory of tort law. Peter Kane in Australia.
Well, it may be a defect of judges who every day decide questions like this, establishing the quantum of compensatory and punitive damages, mainly on the basis of the specific features of the harm, of the damage. Well, the real problem is how one can correctly determine the quantity of the compensation or of the punitive damage.
The ultimate methodological question, right, whether you're a scholar or a judge or a lawyer, should be something like, do you think you'll do better at your job, whether it's being a scholar, teacher, practitioner, judge, or whatever, by reading this literature and thinking about these questions, or not? Is information, maybe enlightenment, useful, or is ignorance better? And it's a serious question because, you know, it is possible to think too much and not act enough. That's certainly right. But mostly scholars think that information and knowledge is good. Some scholars even think that it's good in itself, but could just be mush. So that's really the fundamental methodological question. It comes back then in practical terms to what I was saying at the beginning about disciplinary divisions and different literatures and so forth. I don't care about these taxonomies in principle. There is no in principle reason for them. It's an artifact of modern life and, you know, too much information and all the rest of it. I don't care about the taxonomies, except that often in practice it determines, well, or it strongly influences what you actually do. So if you're in a philosophy department, for example, one tends to only talk to other philosophers and only read their journal and not read all the other stuff that's going on in the world. So division of labour, question at the front, I mean, that's all very well, providing that there are points of intersection where a sensible division of labour is organised so that all the participants understand, as it were, what their job is and what their contribution is. Which is why today is so fantastic, because it's one of these intersection points.
Okay, thank you so much, Larry, and all of you.